Good evening and welcome to all our listeners and watchers on Zoom, of whom I gather there are hundreds. This is a lecture to be given by Christopher Vajda QC, formerly the last UK judge at the Court of Justice. And I'm interested to note that among the topics he will be discussing is the successor jurisprudence to the Achmea decision, which he and I, and indeed the organizer of the lecture from UCL, Martins Paparinskis, discussed very shortly after it was decided in spring 2018 in the just as pleasurable surroundings of an Ottoman seminary in Kavala, Greece. So welcome to UCL. As I've said, Christopher was, if I may say so, a very effective proponent of the common law approach as a UK judge in the Court of Justice, and it's perhaps a shame that he's not still there to influence the jurisprudence, but during his course he did develop a particular expertise in investor-state dispute resolution and sat on, among other things, the opinion on free trade agreement with Singapore and the CETA agreement with Canada. He was before that a member of the bar, whose advocacy I well remember in the Supreme Court, and had a huge experience there in a variety of subjects, both, of course, in the UK courts and in Luxembourg. He's a contributor, a writer, quite prolific in recent years, and a speaker all over the world. He is also a visiting professor at a rival institution, King's College, and a lecturer in private international law at Luxembourg University. He was as a barrister, a part-time judge in the Crown Court, and a bencher of Gray's Inn, as well as a scholar of grande distinction. So, Christopher, we look forward very much to hearing you speak on the subject you've chosen.
Thank you very much for those kind words, and it's a great pleasure to be asked to deliver this lecture tonight, although it's a bit sad that most of the people are not in this room. Now, shortly before I started to prepare this lecture, I came across the following newspaper clip, and I quote, "Secretive court system poses threat to Paris climate deal, says whistleblower. Treaty allows energy corporations to sue governments for billions over policies that could hurt their profits. The German utility Uniper is reported to be seeking nearly €1 billion for the early closure of its coal-fired power plant near Rotterdam. A secretive investor court system poses a real threat to the Paris Climate Agreement, as governments taking action to phase out fossil fuels face a slew of multi-million-dollar lawsuits for lost profits. New data seen shows a surge of cases under the Energy Charter Treaty, an obscure international agreement that allows energy corporations to sue governments over policies that could hurt their profits." Well, I hope this evening to shed a little light on this secretive court system set up under this obscure international agreement, as well as the so-called court system in other international investment agreements. But before doing so, let me begin with a little history. In the 1950s, the world was faced with a different problem, namely how to encourage transnational investments to be made, including those in countries emerging from colonization. The innovative resulting solution, involving, amongst others, Aaron Brock as General Counsel of the World Bank, can now be seen to have four principal features. First, there would be bilateral investment treaties, or BITs, between states whereby investors would, put shortly, be granted fair and equitable treatment of their investments, including protection against expropriation. Secondly, those BITs were to be enforceable at the behest of investors and without the need to exhaust local remedies first. This was part of the shift in public international law from being a system largely regulating the conduct of states inter se to one where individuals are granted rights that can be enforced at their behest, a shift which was recently highlighted by Lord Lloyd Jones in his FAM Man lecture. Thirdly, since rights of investors were granted under public international law, not under any national law, the forum for which an investor could bring a claim would not be a domestic court. And since public international law did not provide any specific judicial forum for resolving such disputes, the forum for investor-state dispute settlement, or ISDS, would be ad hoc arbitration applying public international law. The fourth feature follows on from the third, namely that the remedy for breach of an investment treaty was the classic public international remedy of reparation. And again, consistent with public international law, such reparation had to be full reparation. This solution gave investors legal protection for their investments under a neutral system of law that was not subject to the vagaries of national law. Equally, investors were entitled to have their claims heard by an arbitration panel that would be immune from pressures that domestically appointed judges might be subject to in certain jurisdictions. And from the point of view of the respondent state to a claim, the incursion of a BIT into its national sovereignty was limited, since the investment tribunal could not strike down or interfere with domestic law. The arbitration proceedings would take place outside its own legal system before a form that was in those days indeed secretive, in the sense of not being open to the public, and the only available remedy was damages. The first such BIT was the one between Germany and Pakistan, signed in 1959. Since then, nearly 3,000 BITs have entered into force. They have become a global phenomenon. Indeed, they are not just restricted to agreements between developed and developing countries, as is shown by the claim I mentioned at the beginning of the German utility against the Netherlands. The success of BITs is illustrated by the encouragement given by the European Commission in the early 1990s to the conclusion of BITs between, on the one hand, the states of Central and Eastern Europe, who wish to accede in due course to the EU, and on the other hand, existing members of the EU. The aim was to attract investment in those mainly formerly communist countries by investors from the EU. And indeed, the wide acceptance of the BIT model was underscored by its replication on a multilateral basis, most notably with the Energy Charter Treaty I referred to at the beginning, ECT. This was signed in 1994 and now includes over 50 states as well as the European Union. And it has a dispute resolution procedure contained in Article 26, which enables an investor to bring proceedings against the contracting party before an arbitration panel, and if a breach is established, damages are awardable. In retrospect, the 1990s can be seen as the high watermark of ISDA and BITs and multilateral investment agreements, at least in Europe. Since then, the dispute resolution mechanisms in those bilateral multilateral treaties have attracted growing criticisms. I will focus just on two aspects: the remedy of damages and the suitability of arbitrators adjudicating such disputes. On the issue of damages, there's been growing criticism of large awards of damages by tribunals to investors. Such awards are now invariably published and so attract public attention. Such awards are said by their critics to have a chilling effect on the legislator and its right to regulate in the public interest, such on grounds of public health and the environment. Let us assume that a legislator adopts a measure in good faith to restrict or limit an economic activity on public interest grounds. A court holds that the measure was justified, but on balance does not survive a proportionality challenge. The risk of a large damage award in such circumstances might indeed chill the legislator into either doing nothing or something which does not fully address the public interest problem. It is largely for this reason that English law has eschewed damages as a remedy for unlawful public acts. As Baroness Hale said in Quark Fishing, our law does not recognise a right to claim of damages for losses caused by unlawful administrative action. This principle of English law reflects a similar principle in many other jurisdictions. Thus, by way of example, the Court of Justice has adopted the same restrictive approach to the award of damages in the EU for unlawful action by institutions, and the same for damages against a member state in Factortame number 3. However, the high hurdle for granting damages is compensated in most legal systems, and certainly the English and the EU one, by remedies such as quashing, annulment, and declarations, coupled with the grant of interim relief where necessary. By contrast, the position in international law is very different. An international tribunal cannot itself annul a state measure. Instead, the customary rule of international law is that there must be reparation for international wrongs. This is a well-established principle, originating as it does from the judgment of the Permanent Court of International Justice in the Factory at Chorzo case, delivered almost a century ago, and is now reflected in Article 31 of the Articles on Responsibility of States for International Wrongful Acts, adopted by the ILC in 2001, and I quote, "The responsible state is under obligation to make full reparation for the injury caused by the internationally wrongful act." There is, however, a provision, Article 55 in the Articles, a lex specialis, which permits the principle of reparation to be parted from, and I quote, "where and to the extent the conditions for the existence of an international wrongful act or the content or implementation of the international responsibility of a state are governed by special rules of international law." The commentary to the articles give two examples, remedies under the WTO and the European Convention on Human Rights. In their different ways, both of these regimes modify the rule of compensatory damages with a more tailored regime. Thus, in the case of the WTO, compensation is provided, and I quote, "only if the immediate withdrawal of the measure is impractical and as a temporary measure pending the withdrawal of measures which is inconsistent with a covered agreement." Moreover, compensation in the WTO sense refers only to future conduct, not past conduct. And as many of you are familiar with, in the case of the Convention, the European Convention on Human Rights, Article 41, entitled Just Satisfaction, provides that if a court finds there's been a violation of the Convention or the protocols thereto, and if the internal law of the high contracting party concerned allows only partial reparation to be made, the court shall, if necessary, afford just satisfaction to an injured party. I now turn to the other criticism voiced against ISDS and BITs and multilateral investment agreements, namely the suitability of arbitrators adjudicating such public law disputes. The argument here is that it is wrong in principle for an adjudication body that sits outside the ordinary court system to decide whether a public law measure is lawful. In particular, it is said that arbitrators do not understand the concept of public interest in the way that a judge would. Further, arbitrators should not be entrusted with this job as they do not have the same independence as a judge. They have no fixed term of office like a judge and hence depend on repeat appointments. Some of them are also engaged in so-called double hatting, that is to say, acting as arbitrator in one case and then in counsel in another case, which further undermines their independence. Now, while there are limits to the principle of party autonomy, there is no universal consensus on what those limits are. Thus, in the recent Supreme Court decision in Halliburton and Chubb, Lord Hodge, giving the judgment for the majority, observed that there is no uniform perception of the role and obligation of a party-appointed arbitrator. While as a matter of English law, such persons are required to be as independent as the chairperson, that is not the position in other legal systems. I should, however, add that UNCITRAL and other international bodies are seeking to address the issue of arbitrator independence and impartiality. Nevertheless, as things currently stand, arbitration is the well-established mechanism for resolving public international law disputes, subject to a dispute falling within the jurisdiction of the ICJ or indeed a regional court such as the European Court of Human Rights. As we will see in a moment, the EU is now pushing for a move away from arbitration to a full-time multilateral investment court, MIC. In this endeavour, it has received support from the Court of Justice, which largely but not exclusively for internal constitutional reasons has severely limited the scope for arbitration in international trade and investment agreements to which the EU and its member states are parties. And it's to that case law that I will now turn. I'll look at three cases. The first is Achmea, the case that Lord Mance mentioned in his introduction. This was a case where an arbitral award had been made in a BIT between Slovakia and the Netherlands, and it awarded Achmea 22 million euros in respect of the breach by Slovakia of the BIT. And this was a BIT that had been concluded between the Netherlands and Slovakia before Slovakia's accession to the EU in 2004. It was one of those BITs that I said the Commission had encouraged in the 1990s. However, by the time of the arbitration proceedings, the BIT had become what is known in the jargon an intra-EU BIT, and the Commission's previous encouragement of such agreements had turned into outright hostility. Slovakia challenged the award on the basis that the ISD provision in Article 8 of the BIT was contrary to EU law. The court agreed. It held that an international agreement could not affect the allocation of powers laid down in the EU treaties. The EU had its own autonomous, that is to say, independent legal order. This autonomy, coupled with Articles 267 of the reference procedure and 344 TFEU, required the court to have the last word on the interpretation of EU law. That could only be achieved if questions of EU law are reserved to judicial bodies that are capable of referring a question of EU law to the court under Article 267. Arbitrators sat outside that court system. How then did a question of EU law arise at all under the BIT? The arbitral tribunal was interpreting the BIT as a matter of international law, not EU law. However, the court considered that the dispute in the case was, I quote, liable to relate to the interpretation or application of EU law on the basis that the tribunal must, in determining whether there had been a breach of the BIT, take account of Slovak law, which might include EU law. That is the basis on which EU law was said to come into play. Now, in reaching this conclusion, the court distinguished the position under a BIT from commercial arbitration and a case where the EU itself is party to an international agreement. In both those cases, the court had previously accepted the lawfulness of a dispute resolution mechanism outside the system of national courts. Now, as I have indicated, the court's reasoning in Achmea was based exclusively on the internal constitutional arrangements within the EU. And indeed, the judgment is striking by the lack of any real discussion of the BIT under public international law. In the court's eyes, that was legally irrelevant. Whatever the position in public international law, it could not prevail over the autonomy of EU law and internal EU constitutional arrangements. Nevertheless, even though Achmea is a case which focused exclusively on internal EU constitutional issues, the solution reached by the court, namely that disputes could not be resolved by arbitration tribunals sitting outside the court system, chimes with one of the criticisms of ISDA in BITs that I mentioned earlier. that is to say that such disputes are unsuitable for resolution by arbitrators. And the solution reached by the court was no doubt made easier by the EU principle of mutual trust between courts of member states, to which the court expressly referred. In other words, a Dutch investor should trust a Slovak court to hear his claim. And as a safety valve, there is the reference procedure to the court, albeit obviously on EU, not international law. The absence of any real discussion by the Court of International Law is not, however, the end of the story. The law to be applied in a BIT is public international law, including, of course, the Vienna Convention on the Law of Treaties. Thus, it may come as little surprise that, so far as I'm aware, no arbitral award on an intra-EU BIT rendered after Achmea has accepted the conclusion in Achmea that the ISD mechanism can be disapplied as a result of EU law. A common thread of such post-Achmea awards has been that it is the duty of tribunals to apply public international law, not EU law, which is a regional subsystem of law. And in particular, the Vienna Convention lays down specific provisions for the termination of treaties under international law. Now, just after a year after Achmea, the court had to consider in Opinion 117 the compatibility of the ISD mechanism in what we might term an extra-EU trade and investment agreement, namely the comprehensive economic and trade agreement between the EU and Canada. The opinion procedure, which is laid down in Article 218.11 TFEU, enables a member state or an EU institution to ask the court to rule on whether a proposed agreement is compatible with the treaties. Where the opinion is adverse, the agreement may not enter into force unless it is amended to comply with the opinion. The opinion procedure is a very useful provision, similar to the concept of a declaration in English law, as it promotes legal certainty. Belgium asked the court whether the principle of autonomy precluded the EU giving effect to the ISDS in CETA, and its request also reflected some of the criticisms made of BITs to which I've referred to at the beginning of this talk, namely the chilling effect on the right to regulate and the arbitration process itself. The ISDS mechanism in CETA had its origins in the ISD provisions that one finds traditionally in BITs and the ECT. However, it differs significantly from traditional ad hoc arbitration, as the CETA sets up a permanent tribunal and appellate tribunal, which has the jurisdiction to award compensatory damages for a breach of a CETA provision. The tribunals have, however, no jurisdiction to determine the legality of a measure alleged to constitute a breach of CETA, but may consider the domestic law of a party as a matter of fact. The court held that the ISD mechanism there was in principle compatible with EU law. It confirmed it was inherent in the ability of the EU to enter into international agreements, that it would also accept the jurisdiction of the international tribunal set up under that agreement. Think, for example, of the WTO. It distinguished Achmea on two grounds. First, the CETA tribunal was not an intra-EU agreement between member states, but one between the EU and a third country. Secondly, the tribunal did not have jurisdiction to give rulings on EU law. It could take account of EU law only as a matter of fact. However, the yes answer given by the court was not unqualified. First, the principle of autonomy of the EU legal order was held to preclude the CETA tribunals from, and I quote, calling into question the level of protection of a public interest that led to the introduction of such restrictions by the Union with respect to all operators who invest in the commercial or industrial sector at issue of the internal market. By stating that the tribunal could not review the level of protection chosen by the EU legislator, which the court stressed was a democratic process, the court was responding to the argument also advanced by Belgium that an investment tribunal should not be able to undermine the policy choices made by domestic legislators through the chilling effect of damages awards. In other words, the principle of autonomy imposes a limit on the scope of substantive review an outside tribunal can undertake of an EU measure where that measure is challenged as being contrary to CETA. In other words, this principle of autonomy begins to resemble a term that is perhaps more familiar to British lawyers, named the principle of parliamentary sovereignty as formulated by Dicey. The second major qualification the court gave to its yes answer arose from Article 47 of the Charter on Fundamental Rights. Some of you may recall that this article provides for access to an independent and impartial tribunal. The Charter applies where, put simply, EU law is engaged. Since CETA would be an agreement to which the EU would bind itself, it was subject to the treaties and the Charter. The consequence of this is that the court had jurisdiction to review the ISDS provisions in CETA for their compliance with Article 47. As I said, while the CETA mechanisms had their origins in the ISDS mechanisms found in the BITs and ECT, there were a number of innovations that were significant in the court finding that the ISDS mechanisms comply with Article 47. In essence, the ISD mechanism in CETA is hybrid in nature, combining characteristics based on traditional arbitration mechanisms as well as those of judicial bodies. Thus, it provides for the establishment of a permanent tribunal of 15 members, and that a division of 3 members will hear the case on a rotation basis, ensuring the composition of the division is random and unpredictable. The court referred to point 6F of the joint interpretive instrument that states, and I quote, CETA moves decisively away from the traditional approach of investment dispute resolution and establishes independent, impartial, and permanent investment tribunals inspired by the principles of public judicial systems. And then the court applied its traditional case law on the independence of courts for the purpose of Article 267, when a court is independent for the purpose of a reference, and held that the proposed tribunals complied with that. And as I indicated, the European Commission is itself pushing for an MIC, which is intended to address the shortcomings in the ISDS system, and it regards the provisions in CETA as a blueprint on the way. I come now to the last Court of Justice case, namely the recent Comstroy judgment given in September. It is one of those cases, rather like Donoghue and Stevenson, that I suspect will be remembered not for the result, but the principles enunciated. The dispute was between a Ukrainian investor and Moldova. Neither of them had anything to do with the EU. A challenge had been made to an interpretation of the term investment in the ECT made in an arbitral award, and there was a challenge to that award in Paris, and the Paris court made a reference to Luxembourg. The first and obvious issue was whether the court had any jurisdiction to answer this question at all. The court asserted jurisdiction on the basis that agreements such as the ECT, which are approved by an EU decision, constitute acts of the EU, and that provisions of those agreements form an integral part of the EU legal order. It then added that in order to forestall differences of interpretation between a dispute involving EU parties and non-EU parties, an interpretation should be given whether or not the actual dispute involved EU parties or not. I pause to observe that while the views of the Court of Justice as the judicial body of one treaty party no doubt command respect, they cannot be definitive, in the sense of binding on all parties tasked with interpreting the ECT. The court then went on to consider whether an arbitral tribunal constituted under Article 26 of the ECT would be required to interpret and apply EU law. The answer was yes, because the ECT was an act of EU law. Applying the reasoning in Achmea, the court concluded that the ECT cannot call into question the autonomy of EU law ensured in particular by Article 267 of the treaty. The court then went on to conclude, without reference to the Vienna Convention at all, that Article 26 was intended to govern bilateral rather than multilateral relations between states. Hence, it could not be applied to disputes between an EU investor and an EU member state. In other words, it applied its approach in Achmea a bit to a multilateral treaty between 55 states as well as the EU. So all that was in fact completely obiter to the dispute, which, as I said, was between two new EU parties. Now, a huge amount of electronic ink has already been spilt on this judgment, and it's well outside the scope of this lecture and the time allocated to me to analyse it in detail. I just want to make a few points. As an international treaty, the ECT is plainly to be interpreted in accordance with the Vienna Convention. Now, Article 3.5 of the Treaty of European Union provides that the EU complies, and I quote, with the strict observance and development of international law. And there is plainly a tension between this obligation and the principle of autonomy. And this was explained, I think, rather well by Advocate General Spooner in a case called Arena. And he said this, and I quote, "The coexistence of two obligations, namely that of contributing to the observance of international law and that of ensuring respect for the autonomy of the European legal order, can create tensions which the Union must resolve. In that context, in order for an obligation imposed by international law, convention, or custom to form part of the legal order of the European Union, that obligation must not call into question the constitutional structure or the values on which the European Union is founded." He then refers to two judgments to illustrate the point, and I'll just look at the second one. And that is the case of Cardi, in which the court held in substance that the obligation imposed by an international agreement cannot have the effect of prejudicing the constitutional principle of the European Union that all EU acts must respect fundamental rights. And he closes by saying this: "Those two apparently contradictory interpretations of the relationship between EU law and international law illustrate the importance of maintaining a balance between safeguarding the European Union's constitutional identity and making sure that the EU law does not become hostile to the international community but is an active part of it." Cardi, which was mentioned by the Advocate General, was probably the most famous example of the court in Luxembourg departing from EU international law, because that was the case where it precluded member states from complying with their international obligations, namely a UN Security Council resolution. However, in that case, it carefully explained why fundamental rights in EU had to prevail over international law. Indeed, that was a case where no rights of Mr. Cardi under international law were removed, but rather EU law granted him rights that did not exist in international law. EU law was used, if I can put it like this, a shield and not a sword. By contrast, the effect of both Achmea and Comstroy appears to be that EU law precludes, at least within the EU, the enforcement of lawful awards made under international law. The basis on which the court found the ECT to be part of EU law was slim. it relied solely on the fact that there was an EU decision to accede. However, if the ECT is part of the EU legal order via the decision to accede, it does not therefore follow, in my view, that the ECT loses its character as an agreement governed by international law. This means that the ISDS provisions in Article 26 have to be interpreted in accordance with the principles of interpretation under Articles 31 and 32 of the Vienna Convention. And I mentioned earlier the usefulness of the opinion procedure, and in my view it was perhaps a pity that that opinion procedure was not invoked, as it could have been at the time that the EU was intending to enter into that agreement. Well, that's now the position in the EU, and as you can see, it's heavily influenced by internal EU constitutional arrangements. And I will now turn in the much shorter part of my lecture to the position now in the United Kingdom. I'd like to start with the internal position. How are trade agreements to be brought into UK law, and how does Parliament scrutinise them? As Walter Bagehot observed in the late 19th century, and I quote, "Treaties are quite as important as most laws, and to require the elaborate assent of representative assemblies to every word of the law, and not to consult them even as to the essence of the treaty, is prima facie ludicrous." Happily, things have moved on a little since then. Under the Constitutional Reform and Governance Act 2010, which effectively put onto a statutory footing a previous convention, Parliament can, in effect, block ratification of a treaty. The government may not ratify a treaty for 21 sitting days after being laid before Parliament. Parliament could resolve that the treaty should not be ratified, and in theory, Parliament could continue in this vein, giving it in effect a veto. However, this power has not been used, and whether it will be used remains to be seen. Where a trade agreement requires primary legislation to be changed, Parliament's consent will be needed, of course, to amend that legislation. However, where a trade agreement requires changes to secondary legislation, Parliament's role is much less important. Much of the UK's pre-existing food and environmental legislation has been inherited from the EU and is to be found in secondary legislation. And concerns have therefore been expressed that future free trading agreements, FTAs, could lead to a lowering of those standards without sufficient parliamentary scrutiny. Steps have been taken on a non-statutory basis to improve parliamentary scrutiny in this country. For the trade talks with the United States, Australia and New Zealand, the government set out its negotiating objectives alongside a response to the public consultation as well as an initial economic assessment. The government will publish an independently scrutinised impact assessment of the deal, allowing time for the relevant select committees to produce a report on the FTA and to enable the new Trade and Agricultural Commission to report. Nevertheless, the UK's legal powers, while similar to those of the Australian and Canadian parliaments, remain considerably less either than that of the EU Parliament or the US Congress. By way of example, the EU Parliament has a legal right to be informed of the negotiating mandate, the negotiating process, and its formal approval is required for ratification. I will now close by looking at what I might call the external position and the presence or absence of ISDA mechanisms in UK FTAs. The largest trade and investment agreement that the UK has concluded post-Brexit is, of course, the agreement with the EU, the TCA. That contains no ISDS provision, which is perhaps not surprising given the problems and the hostility of the EU that I mentioned in the CETA opinion. That is to say that one needs to have something like a formal court structure as opposed to arbitration. The TCA has, however, been incorporated into UK domestic law, and I'll come back to that in a moment. Nor does the Comprehensive Economic Partnership Agreement between the UK and Japan, which came into force at the beginning of this year, contain an ISDS mechanism. However, as I understand it, the objective of both the UK and Japan was simply to roll over the existing EU-Japan agreement before the UK's transitional period in the UK expired at the end of last year. There's no ISDS in the UK-Japan agreement, and so there's not one in the UK-Japan one either. The next agreement in the pipeline is the proposed UK-Australia Free Trade Agreement. The current proposal provides for no ISDS mechanism, although UK ministers had stated in Parliament that the UK supported such a mechanism. However, it is well known that the US ISDA mechanism is politically extremely sensitive in Australia as a result of a claim, in the end unsuccessful, brought by Philip Morris against Australia, challenging public health legislation on the packaging of tobacco. By contrast, as a member of the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTWP, it's a bit of a mouthful, Australia has accepted ISDS in that agreement, and that is an agreement to which the UK wishes to accede. The position in the proposed UK-Australia FTA prompts the question whether one always needs an ISDS mechanism that stands outside the national court systems of both countries. Both the United Kingdom and Australia have an independent judiciary and a well-established public law regime. One could, as an alternative, envisage that the FTA would be incorporated into the domestic laws of both countries. There is a recent precedent for this, namely the TCA itself. The TCA, unlike the EU treaties, does not have direct effect, but it has been incorporated into UK domestic law by Section 29 of the European Union Future Relations Act 2020. And as Lord Justice Green recently observed in the Heathrow Airport duty-free case, this will require courts to have regard to, and I quote, the principles of interpretation to be applied to the TCA. The Act, that's to say the UK Act, cross-refers to the TCA, which itself incorporates the Vienna Convention on the Law of the Treaties. To my mind, this could provide a template for bringing provisions of an FTA between the UK and another state into their respective domestic legal systems. Of course, it would no doubt be said that to give jurisdiction to both the Australian and UK courts to interpret the FTA in accordance with the Vienna Convention risks divergent judicial pronouncements on the same legal text. Therefore, one needs some judicial body with an exclusive jurisdiction to provide the final word. In my view, the likelihood of divergence occurring should not be overstated. In any event, even with ISDS tribunals, one can have divergence between one tribunal and another. The risk of divergence between domestic courts could, in my view, be countered by dialogue between the parties, and as a last resort, the two states issuing interpretive guidance for future cases, as indeed provided for in the CETA. I would add that even many modern international treaties, even though many modern international treaties have specialist international bodies for dispute settlements, there are many that do not, and that are interpreted and applied exclusively in domestic courts, for example, the New York Convention and the Refugee Convention. Of course, I recognize that the approach I've suggested may not work between states where, to use the phrase coined by the Court of Justice, there is not the same degree of mutual trust between the national courts. But the approach that I have suggested would provide an alternative to ISDS, and something that Aaron Brockes and his colleagues in the 1950s might have approved of.
Well, thank you, Christopher, for that extremely instructive and wide-ranging talk. And I think we'd all want to thank Judge Vajda once again for an absolutely excellent evening. Thank you very much.